Record. Hi, I'm Russ Bleemer, editor of Alternatives to the High Cost of Litigation at www.altnewsletter.com and it's ctradr.org. That's the website of the International Institute for Conflict Prevention and Resolution in New York, which publishes Alternatives with John Wiley and Sons. I'm pleased to be back here recording this on YouTube with Dallas arbitrator Richard Faulkner, Angela Downs, Assistant Director of Experiential Education and Professor of Practice Law at UNT. That's the University of North Texas, Dallas College of Law. And Philip J. Loree Jr. Phil is in New York. He's an arbitrator, a litigator, and all three are back to join us and discuss some of the hot topics now with the U.S. Supreme Court in their activity in the arbitration world. In the current 2021-2022 term, we had a case. We've got another arbitration case. The first case was dismissed ahead of the argument date. The second case was argued. Another case was added just last week. Now there's two more set for conference on December 3rd, about 10 days from now, and those may be added, if not for the current term, then next fall. That's all to be determined. We're going to pick a starting place, and that's with the latest add. That's a case called Morgan versus Sundance, and it brings back to look into our view a seminal decade-old case that permitted mandatory arbitration teamed with class waivers. That was for consumer cases. That's the AT&T Mobility versus Concepcion case. The court agreed to hear Morgan versus Sundance on Monday, November 15th. And the official question presented is, does the arbitration-specific requirement that the proponent of a contractual waiver defense have to prove that prejudice is a part of the action and therefore violated the court's instruction that lower courts must, quote, place arbitration agreements on equal footing with other contracts, okay? The court's instruction was from the AT&T Mobility case. Putting that another way, what the court is asking here is there's perhaps too much emphasis on arbitration. Morgan versus Sundance is an employment case, and the plaintiff said that her employer, which is Taco Bell, had waited just too long to move on arbitrating her Fair Labor Standards Act case. The Eighth Circuit requires that Taco Bell would have to have prejudiced the other party to waive her right to arbitration. Is this a preference for arbitration? Is it rather than placing arbitration on equal footing with any other contract? Now, it's a fairly straightforward case interpretation question, but it invokes the specter of the tough arguments we heard in the lead up to the 2011 AT&T Mobility case about whether mandatory arbitration teamed with a waiver of court processes is fair to consumers, and here employment plaintiffs as well, who are also subject to mandatory arbitration with class waivers under the 2018 Epic Systems case. We have a good write-up, including resources on Morgan, so you can go back to this material. It deals with the case itself and the cert grant. That's on the CPR Speaks blog, which will be linked here, and it's by our friend DC arbitrator, Georgetown adjunct professor Mark Cantor. So the question for our panel here, did the court accept the Morgan petition on the Eighth Circuit's need for prejudice as a sign it will reverse here? Will this AT&T Mobility requirement that the former Taco Bell worker must show she was prejudiced by the employer's actions, so the arbitrations waived under the Eighth Circuit standards stand? What do you think? Who would like to go first?
I'll volunteer. I don't think it's going to stand. Quite frankly, I think the court has been looking at the text of the FAA. And one of the things that as an arbitration practitioner, I've noted for years is that there is that circuit conflict. There's a conflict between numerous state Supreme Courts over whether prejudice is or is not required. And let's face it, waiver is generally ascertained by looking at the unilateral activities of the person or entity that is supposedly engaging in the waiver. And the way that the arbitration law stands right now, it encourages tremendous gamesmanship, much of which is completely contrary to the articulated views of using arbitration as a simple and a cost-effective basis for dispute resolution, because prejudice isn't being looked at as carefully by some of these courts as they should. most lawyers who get removed don't realize they're about to engage in a 6 to 8 month, sometimes 1 year battle over just removal. And for a party that is seeking to bring a case forward in litigation, that's a substantial period of time. On commercial cases, I can say, absolutely, it's not uncommon for my clients to spend $70 to $80, $90, or $100,000 fighting over removal. And inevitably, the party that has removed is tempted to try for kill shots. They go in and file a 12b6, or if they don't do that, they try to eliminate some, but not necessarily all, of the plaintiff's claims. And that has been a tremendous benefit for the company, the entities, typically a company that remove. Because if you can kill a case off, which 80% of federal judges will grant a summary judgment if given the chance, why not take it? And, when you contrast that in Texas, state judges almost never grant summary judgment. Federal judges almost always grant summary judgment. Why not? I mean, if you're a defendant, why not remove and go ahead and try and eliminate the case? And you can see that happening with business interruption.
Rick, that's a perfect segue back to the original point. Is this, Professor Downs, is this too much emphasis on arbitration? Because that's what the court is looking at by its own terms of the question presented.
I could never say that it's too much emphasis on arbitration.
I'm sorry. The court said, is it too much of a preference for arbitration?
No. But I have to agree with Rick. I think that this lends itself to shenanigans. This is an opportunity for an astute parties to use the system to their advantage, to actually go in and to navigate, particularly if one of the parties does not have the resources, does not have the sophistication as the other party, they can delay until that party that does not have the same resources gives up. And then that case is over and they can move forward. One of the things that I found really interesting about this case was there was a group of law professors who actually said, hey, guys, we want to, we propose that an amicus be filed with respect to this case. They said that they had an interest in the case. And it was an interesting composition of law professors. They were professors that focused on contract law and arbitration, which I thought was fascinating. And what they were interested in was ensuring that there was a proper interpretation of contract law and arbitration law principles in federal and state courts. And this again goes back to what we've just been discussing, because the federal interpretation of cases can be so vastly different from state court, with how cases are heard, with removal practices, summary judgments. And so they were saying, hey, we need to go back to ensure that these cases are being interpreted correctly, that there's an understanding on how the lower courts have failed to properly apply the Federal Arbitration Act's equal treatment principle, and that they have improperly created a federal common law of arbitration waiver rather than applying state contract law principles to the question of when a party has waived its right to ensure the arbitration contract. So those law professors were saying, hey, we need to look back at the state law and not look at the federal law. And I thought this was brilliant. It was brilliant.
The question of whether or not arbitration is on equal footing with regular contract law, just by its mere existence in the manifestation of that brief, indicates they think that the tilt has gone a little off. And of course, that's what the court has taken the case and they're going to look at. Phil, is that what's happened? Are those professors right?
Oh, absolutely. Absolutely. And you can take this principle back. I just figured out Prima Paint, where the court first said that arbitration is not a super contract. But that's exactly what's happened here. You've got, you have a state law contract doctrine of waiver, which is Rick and Angela have pointed out, just requires an intentional relinquishment or abandonment of a known right. There's no additional requirement of prejudice. That is something that is you can trace to the equitable doctrines of laches and estoppel, where you have to have something more than just inconsistency or delay in the case of laches to demonstrate that non-enforcement. So here, what you've had is this issue, as you said, it goes back at least as far, it goes back even farther, certainly to Concepcion, but even before then. And interestingly enough, in 2011, which I think was around the time Concepcion was decided.
That was the year, yeah. It's celebrating its decade birthday now.
Right. So the court actually granted a case, Citibank versus Stock, that raised the same issue. But unfortunately, that case never made it to the Supreme Court because it was settled and it was mooted. So when this case, I don't know if they ever considered granting it at another time, but they've come now after 10 years and they're ready to take it again. I think that's when I first heard about this case. I thought I was pretty confident that they'd take it because they did agree to take it 10 years ago. And if anything, in that since Concepcion, since Stolt-Nielsen, all that, there's been a huge emphasis on the fact that arbitration is a matter of contract, and then on top of that, the equal footing principle that arbitration is a matter of contract and should be treated like a contract, and it shouldn't it shouldn't be a super contract, just as it shouldn't be an inferior contract.
That's great, Phil. Let's go back. I'm sorry to interrupt you, but let's go back 10 years ago to AT&T Mobility and bring it forward and look at the language, because that is at least a possibility of what's going on here, the possibility of revisiting AT&T Mobility, what extent it'll happen. 3 votes that backed AT&T Mobility versus Concepcion are still here. Chief Justice Roberts, Associate Justices Thomas and Alito. 3 of the votes against it are still against AT&T Mobility. The minority are still in place. Associate Justices Breyer, Sotomayor, and Kagan. Now, what are the chances the 3 new justices, the 3 newest justices, join in with the liberal contingent and decide that AT&T Mobility versus Concepcion has made a preference for arbitration? What is the chances that they are going to go with the AT&T Mobility majority? I'm wondering where there's room for one to side in which one they're gonna come down on. This case is being argued by the same lawyers that argued and lost for Concepcion, the public interest law firm in DC, Public Justice. They're back here now as a different lawyer, so they're getting another shot at it. And in fact, what we have here is this textual argument. I'm thinking that the court and where the justices are going to go, a couple of years ago, January 2019, had a unanimous 8-0 decision in an arbitration case by new Justice Neil Gorsuch, his first crack at arbitration. That was a specific Section 1 case, but here the court took the case in Sundance based on Morgan versus Sundance, based on a challenge under the FAA text. Specifically here, the petitioner is saying that the prejudice requirement on the contractual waiver analysis violates the wording of FAA Section 2, which Section 2 says agreements to arbitrate future disputes must be placed on an equal footing with other contracts under Supreme Court law. That Supreme Court law is Rent Center West versus Jackson. That's where the court attributes it to. We know that has a long history as well. The court also says there's nothing in the language of Section 3, which is often used in litigation conduct waiver analysis by courts, that says that there is a requirement of prejudice to stay arbitration. So they're saying there's public justice is arguing there's no prejudice requirement in 2, there's no prejudice requirement in 3. So is this argument by public justice targeted at that Gorsuch context, the textual interpretation arguments that he presented in New Prime a couple of years ago that had an 8-0, one of the justices recused. That was an 8-0 case. Is this argument targeted? Perhaps not at bringing the liberals, bringing the new justice into the fold with the liberal side, or bringing new justice into the fold to the conservative side, instead trying to produce a majority opinion with this focus on textual authority that Gorsuch has given us? Rick, I know you were involved in Rent a Center, so I want to go to you first.
And my drafting while getting Supreme Court approval has certainly turned into a Frankenstein's monster that's kept us busy for many years. A couple of things. One, I think it is aimed at the textual analysis of the FAA, and it's not just Justice Gorsuch, but in the Shine 2 case, where the Supreme Court dismissed on writ improvidently granted, in the oral argument, there were questions about the specific text of the Federal Arbitration Act and where lawyers found support for their positions. One of the things that was mentioned earlier, and Phil has alluded to this, is arbitration agreements are not super contracts. And I wondered in Morgan v. Sundance why the responding party refused to consent to the amicus brief. And then I looked at it and saw the amicus brief is really authored by Professor Frankel, who wrote an article in 2014 saying the arbitration clause as super contract, the same Professor Richard Frankel from Drexel University School of Law. So I have a feeling that Sundance's lawyers said, wait a second, this is coming in against us. There's nothing good that these guys are going to say about what we're doing and the games we're playing. So let's try to keep them out. It didn't work. The court agreed to allow the law professors to come in. But I think one of the justices once said, we're all textualists now. And so we're looking at a very targeted attack by public justice on the text of the FAA. And let's face it, y'all, a lot of gamesmanship can go into the removal and or the attempts to get a tactical advantage by using the fine points of arbitration law from decisions like Rent a Center v. Jackson and taking that and using it to the disadvantage of the less sophisticated party. If any of us are involved in the case, we know what's going on, we understand it. But all too often, when some of these plaintiffs have their cases removed, they're suddenly totally out of their depth. Our chief judge in the Northern District of Texas years ago estimated that 90% of the lawyers in Texas are not admitted to the federal bar. So automatically, 9 out of 10 of them that get removed are sitting there going, now what the devil do I do? And that's a tremendous advantage for those of us who are constantly in federal court. We know the rules. We know how the judges are inclined to act. And, you've got to have scholarship in your briefs at that level, which all too often, is not conducive to success by lawyers who shoot from their hip. The good news is it's beneficial to our sophisticated arbitration practitioners. The bad news is it's not for the consumers and for most employees. And let's face it, Ms. Morgan is the classic example of an employee facing a major entity. And y'all wouldn't know this, but I'm friends with the former deputy general counsel of Sundance. And so I know exactly how, they operated. And they're not just a little operation. They're about 500 Taco Bells. Oh, sure.
So it's a big franchise.
It's a big franchisor.
Big company.
Franchisee. It is a large and sophisticated
franchisee, yeah.
They know exactly what they're doing. And I'm not saying I would do anything any different. Not at all. I've done exactly what they're doing.
Rick, can you just for the record state your involvement in Rent a Center West for our viewers?
I drafted the original language for Rent a Center and specifically assigned and delegated arbitrability to arbitrators. If you read the language, you'll see some of it is very peculiar. That's because I'm French trained from New Orleans and practiced law there for a number of years. The Supreme Court upheld and validated what I did in that, but I will tell you candidly, I was drafting with a view to keeping the Ninth Circuit Court of Appeals from interfering in what my corporate clients were doing. And I tried like the devil to make arbitration as palatable and as neutral appearing while preserving an advantage. I mean, let's face it, that's what we do when we represent corporate America.
Well, that advantage is also a perfect launching point, because there's supposed to be what comes out of that advantage. The courts are supposed to look at the contracts on an equal footing. But right. You started off, Rick, talking about the gamesmanship part. And you also mentioned Professor Frankel, who has said that when, and he did it in our pages in the past year, when corporations do the gamesmanship, they are really looking for an advantage in a way that is hostile and anti-arbitration, even if they're trying to invoke arbitration. Professor Downs,
I'm sorry, I was going to
move Professor Downs onto the gamesmanship point, but why don't the two of you discuss that? Feel free.
Definitely. But, I think part of the reason that this is so troubling is because we know at the core, arbitration is supposed to level the playing field. So when it does not, the red flags go up immediately. And so I think going back to the interpretation of what arbitration was meant to be, it was not meant to be this gamesmanship. It was not meant to be this tool where, it's literally a David versus Goliath situation, as what you've described for Ms. Morgan. We've got to get back to that and say, okay, we want to use this as a tool that can be effective for all.
And look at the weaponization of arbitration rules. Look at the way that so many of these arbitration agreements are crafted and drafted in ways that totally disadvantage the weaker party. I was not looking out for employees when I drafted the language that became Rent-A-Center. Not at all. I represented companies. That was it. And I pushed the limits as far as I thought I could get away with within the then context of a Ninth Circuit that was hostile to arbitration. And the Supreme Court said, hey, you made it. Now, I will tell you that what it has become over the last years and the succeeding decade has become very problematic for many of us, because we're seeing things like rules burying arbitrability in Rule 7 of the AAA commercial rules. As long as we have arbitration applied to consumers and employees, relatively unsophisticated parties, there will be this huge asymmetry of information, of resources. And arbitration wasn't intended for that. It was for commercial merchants that were trading in Rhodes and Rome and Alexandria, when those were the dominant empires of the day. It was in the Constitution of Athens in 486 BC. It wasn't intended to be used against individuals like it is now. And now arbitration provisions are ubiquitous. They're everywhere. You can't really do business in America today unless you run into arbitration. Now, many businesses are schizophrenic. I represented a lot of auto dealers. They love arbitration when it's against consumers. Gets rid of those obnoxious class actions. They hate it when it's against the manufacturers like Ford or Chrysler in particular jams arbitration down dealers' throats, despite the special federal law we had passed. But, most smaller and mid-sized businesses aren't enjoying the expense of arbitration now.
That's great, Phil.
Yeah.
Rick, I appreciate it. I want to move on to 1782 and to look through jurisdiction, but I want to give Phil a last shot at the equal footing discussion in Morgan. Do you want to?
I'll be very quick. And I think when I like everything I'm hearing here and agree with it. And it just, to me, reinforces the way that the court really should rule on this issue, which is to take the prejudice requirement out of waiver, treat it like any other contract. That's perfectly consistent from a textual perspective with Section 2, and it takes the games personship out of arbitration, and it's going to take a lot of pressure off the courts too in terms of time spent resolving disputes. If there's going to be arbitration, you got to enforce it. Then you got to enforce it like any other contract. In this case, you find yourself in litigation. If you have an arbitration clause, you better assert it before you take a position that's inconsistent and evident, or evidence is an intent to abandon arbitration.
Thanks. If we could move over to 1782 and try and look ahead and try not to look back, which is almost unavoidable when you're talking about the Supreme Court taking cases. But there's an AlixPartners case and a ZF Automotive case. They're scheduled to be discussed at a conference a week from Friday. That's December 3rd. Both involve the question of the reach of 28 U.S. Code Section 1782. That's titled Assistance to Foreign and International Tribunals and to Litigants Before Such Tribunals. Okay, this is another simple question before the court that over the years has gotten complicated, particularly in recent years. Under the law, it's real simple. U.S. federal district courts can grant discovery requests to foreign and international tribunals. The question's half a dozen, 5 words. Does that include arbitration tribunals? When I started out at the beginning, I was talking about things being taken and things being dropped and being dismissed. We thought this question was about to be settled. There were arguments in a case scheduled the first week of October, which would have settled, as far as we know, depending what the court did, the entire discussion. It was a case called Servotronics versus Rolls-Royce. But the underlying arbitration didn't wait for a ruling on this discovery question. It was held in May after the court accepted the case. An award was issued in July while the court was scheduling the case. The parties asked the court to dismiss the case in September. The request was granted. CPR's friend John Pinney, he's at the Graydon Law Firm in Cincinnati. He's pointed out there's a whole bunch of those cases out there, and these are 2 of them. It seems like a no-brainer for the court, having agreed to hear Servotronics once this year. It's going to take one or both of these cases next week on the 1782 limits. The full disclosure, Mr. Pinney has written an amicus brief on behalf of the CPR Institute, the International Institute for Conflict Prevention and Resolution. That's where you are, to remind you, on YouTube now, on their channel. He wrote a brief in the AlixPartners case, okay? And it urges the court to take the case and decide yes or no whether the law applies to arbitration tribunals. But we do not, CPR does not take a position in the case. CPR's most recent previous amicus brief, CPR does not do too many of them, but its most recent one was also pinned by John Pinney, and it urged the court to take the Servotronics case last January, and that happened. But then, as discussed before, it didn't really happen. There are some slight differences between AlixPartners and ZF Automotive. If you're in the case, there are major differences. Briefly, the AlixPartners case involves ISDS, that's arbitration involving a foreign government. Some of you know that. A lot of you that do it know it is investor-state dispute settlement. The ZF Automotive case involves a private arbitration process. So the court could take either case. The court could take both cases, or maybe having had a chance to catch its collective breath after all these months and after Servotronics, it could even decide to stay out since these cases get arbitrated and these decisions, for better or worse, are made or are mooted, which has been an issue in this case. Why is it important that the court take this case and clear up the 1782 issue next week, or one of these cases? Phil, you want to kick this one off?
Well, I was going to defer that one to Rick.
Okay, Rick.
I'll happily give it to Phil because I've already briefed this long ago and didn't succeed with trying to persuade a federal court to assist the tribunal. Phil, I think, has the most recent scholarship on this.
Well, it's a very important issue from the standpoint of international judicial assistance, and it's an issue that also has implications for the reverse situation where you have to go to a U.S. court and get letters rogatory to have a discovery conducted abroad, which of course raises a whole lot of other issues, which we won't get into right now. But the main thing about it, as I've always seen it, was what is a tribunal? within the meaning of these statutes. That's basically what it boils down to. Is a tribunal only a governmental adjudicatory body, or does it include an arbitration panel? And certainly in the Second Circuit, you had very in the Bear Stearns case, a very intense discussion of all this, and all sorts of legislative history with Hans Schmidt and others, I believe, and then more recently, we've had in dictum, there was a Supreme Court case where it sort of seemed as if that what the Supreme Court would interpret tribunal to be would be to include an arbitration tribunal.
That was Int'l.
So,
Is that the
yeah, it was Int'l,
case
right?
In 2004. Yeah. So it's a yes or no question, where we have, I think, 2 circuits now who said yes, and 3 circuits that said no, all in a lot of words,
Yeah.
a lot of explanation.
Well, that's right. A lot of complicated, and really it just comes down to, and here you talk about textualism. Well, this is a great opportunity for it, and I know that some of this has to do with interpretation of what Hans Schmidt taking one interpretation when the statute was passed, and then and then another one later on in a subsequent law review article, which was different, and what does all that mean? And so I don't. I would hope that that they'll rule that a tribunal includes a foreign arbitration tribunal, and I think that would probably make the most sense from it. And another thing too is to look at this case. You go to Europe. Let's say you're in the UK, for example. They expect that other countries will grant them this type of assistance, and so they take a more expansive view, I think, of what
the dismissed Servotronics case. The arbitration was held in May in London, and they had there was a question whether it was going to be provided, but the panel, which is the king there, was able to proceed on its own without it.
What I meant is you had one EU country, going to England and say, "Give us this discovery." They're not going to turn around and say, "Well, you're not a tribunal." They'll provide that kind of relief under I think their version of the Arbitration Act 1996, which was that, Rick? Was that based on? It was
based on a prior English arbitration law.
Yeah.
And
right.
it kind of updated it, at least when I was at Oxford. It was described as a necessary update because there were some aspects of English arbitration law that frankly were not really appropriate for the 1990s. And, I'm in the same camp with Phil. I hope the court will take this case. I'd like to see them grant the cert and grant it as to all of the potential parties, because I can see from my own experience, businesses have spent tens of millions of dollars on fees for lawyers on these very issues, sometimes successfully, sometimes not. And particularly for Europeans, and having been educated in a French legal system and knowing how some of the Francophone countries think, it just boggles their imagination that we can have the kind of circuit splits on these things that are completely foreign, no bad puns intended, to their entire legal experience and education. And
That's
so
right.
It's very problematic. I mean, I don't really care which way the court comes down, but please give us the guidance so that we know and can advise our clients appropriately, because right now it is a muddled mess.
Totally.
And we need to have some guidance.
We'll provide some resources so you can dive down that rabbit hole if you'd like. I was going to say, Angela, I'll give you the last word. Go right ahead.
Absolutely. And I think that's part of the problem is the guidance. There's no guidance. And, anecdotally, there's been an increase in how this statute has been applied and how it's been applied in particular to class action suits as far as a way to not permit discovery. And so again, you've got that gamesmanship coming in where, the big companies are using this as a mechanism to push the little guy out of the way. So, I think the direction from the courts is something that would be welcome. It would be a way to talk to clients, to give them a clearer road of what's coming before them. And it would also help practitioners to have a practical application of how to get ready and prepare for these cases. Because right now it's completely innocuous. You don't know what's going to come at any turn. And so you're preparing for everything, and you really cannot advise your clients because you don't really have a clear understanding of what might happen. So I think this would be welcome.
Yeah, Angela, Phil and Rick would like the foreign or international tribunal to include arbitration tribunals. Are you with them on that as well?
Definitely,
okay.
definitely,
okay.
definitely.
Just to be clear, the administrator and provider of this YouTube channel did not take that position, but it did ask the court to decide one way or another to remove the uncertainty. Now we have a third, and thank you for watching and staying with us, but we have a third November 2021 matter before the Supreme Court on arbitration. In Badgerow versus Walters earlier this month, the court appeared to express real skepticism about a petitioner's argument that federal court jurisdiction over an arbitration matter under FAA, under Federal Arbitration Act Section 4, that enforces the submission to the ADR process does not also carry federal jurisdiction over to later FAA sections on confirming and overturning. So federal courts have jurisdiction on submission to ADR and getting ADR going, but not on confirming awards and overturning awards later. The question again is whether federal courts have subject matter jurisdiction to confirm or vacate under the specific sections 9 and 10 of the FAA. Under those sections 9 and 10, the only basis for jurisdiction is that the underlying dispute involves a federal question. The Supreme Court has been crystal clear, and it puts it in the questions presented in Badgerow, that it does not itself, the Federal Arbitration Act does not itself confer federal question jurisdiction. The federal courts must have an independent jurisdictional basis to entertain matters under the FAA. So under Section 4 on enforcing arbitration, what the federal courts can do is to look through. That should be in air quotes. Look through. It's a term of art. The federal courts can look through to the underlying litigation that precedes the Section 4 question as to whether or not it should be submitted to arbitration to determine whether it can order a case to arbitration. So why shouldn't this look-through principle that applies to Section 4 not apply to Section 9 or 10 on vacating or conforming an award, or should it apply? The petitioner's attorney said, well, it was a contextual argument again. It was because of language differences in Section 4 versus 9 and 10. This is lawyers' law that lawyers love and is pretty dense. Why is this important, and why should look through be allowed or not allowed for confirming or enforcing a law?
Consistent with my right learned friend Dan Geiser's approach to the argument. It is a lawyerly argument on text. I don't think it has the proverbial snowball's chance in Hades of working. Federal look-through jurisdiction should be recognized here. And one of the difficulties is that the FAA is the only federal statute I'm aware of without a jurisdiction provision. And so it causes innumerable, otherwise unnecessary problems. And with the court's predisposition towards favoring arbitration, I think they're going to look through jurisdiction. And it isn't going to take them very much to do. If there is any 8-1 or 7-2 decision, I think it's going to be on this case. And unfortunately, I don't think Dan is going to do very well on this.
I'm sorry again to interrupt you, Rick, but again, we'll link to it in a blog item that I wrote for CPR Speaks here. We looked at the argument and listened to it when it was provided. And I wrote that Dan Geiser, who represented the employee here, who alleged discrimination against the big financial services company, Ameriprise, had a very tough argument. And as I noted here earlier, the justices really looked at it skeptically. Phil, Angela, can one of you please say why the employee is going to win here so that at least one of us can be right about the decision in this case?
I can't say that I think the employee is going to win if I understand the facts of the case. I think I'm with Rick, and Rick actually introduced me to Dan Geiser. I think he's a very good lawyer. He's got a heck of a excellent lawyer, but he's got a real tough case here. And that's what about a lot of Supreme Court litigation is about, or any litigation. I mean, you get tough cases, even no matter how good a lawyer you are, your chances of winning are not going to be great. From a personal standpoint, my quote unquote understanding of all this, based on what law we've had to date on it, has been that the actual jurisdictional hook is in Section 4. It applies all over, because if it doesn't, then you're left with a sort of a patchwork kind of solution as to what courts you could have a situation where you had a federal court compelling arbitration, and then you get they could purport, even if they purported to retain jurisdiction, you could possibly still go to the state court. And, or let's say they didn't, then you might be required to go to a state court to enforce the award. And it just doesn't make a lot of practical sense. That said, there was a textual hook for Dan's argument. It's just, I don't think it's one that's going to win here. And I'd like to see the employee win on this, but I don't know if it's going to be a huge loss on the other hand, because they're basically betting they're going to do better on state court, but it's a motion to vacate, I suppose, from her standpoint, and that's always tough, even in state court.
As optimistic as I generally am with these things, I don't see. I just think it's an uphill battle.
Absolutely.
I wish that there was more, as they say, meat on the bones to really push this case. But I think it's one where, as dynamic as you're telling me the lawyer on this case is, I think it's going to be very, very difficult to prevail. And like everyone here, I would love to see the little guy win. But I don't think this is the setting for that to happen.
The little guy in this situation, a woman who's facing discrimination claims, is seeking to have the federal court's jurisdiction over enforcing the award knocked down because she wants it back in state court.
Definitely.
And Angela, that ties into what you were saying about 1782.
Absolutely. I mean, and it goes back to the gamesmanship. That's kind of been the through line with everything that we've said. But having the case get back to state court, I think, would make a huge difference, particularly in this case.
I will chime in because I practiced in those very courts years ago. I mean, that's where I'm from. And quite frankly, I will be willing to bet you dollars to donuts that state court will be hostile to arbitration and might very well vacate an award if they can find any basis for doing so. And, when you were talking about representing little guys, my definition of that includes my small and mid-sized businesses. So I don't generally represent consumers or individuals. And, even clients of a small and mid-size, arbitration has become problematic because it's so confound expensive.
It is.
And inefficient much of the time. Former Lord Chief Justice Neil Kaplan decried the over-litigation of arbitration cases recently in a speech in Australia where Neil still practices. And, let's face it, y'all, all of us have appeared in numerous arbitrations or in courts on arbitration issues that if the FAA were rational and textually interpreted according to its exact language, would never have happened. And that's one of the big problems in this area.
I think that's why it's so important for the Supreme Court to really review these issues, because it's, we're focusing on the so-called little guys but it is, I agree with you. It is the small and mid-sized businesses also that they're getting plagued with having to navigate arbitration. And it's a very costly proposition for them when that's not the initial purpose of what arbitration is about.
I don't think the Supreme Court is going to do what Rick had suggested it could do here. It's not going to speculate on what could happen to this case in state court. But that hostility to state court, some have said, is what has motivated the Supreme Court's perhaps over emphasis, going back to the beginning, over preference to arbitration. They're not going to have to go that far to find here against Badgerow, the employee, but it's possible that hostility to arbitration could underlie it. So,
Russ, you raised something that is going to be really important, which is the section of the Federal Arbitration Act pertaining to the opportunity to obtain a jury trial on the, quote, making of the agreement to arbitrate, because the U.S. Ninth Circuit has several times in the last 2 years remanded cases back to the district court in employment areas in particular on the issue of the making of the agreement to arbitrate and sent it back for jury trial. Now, the Fifth Circuit engages and indulges in every possible way to stop the making of the agreement to arbitrate from going to juries. And it's in many ways a similar analysis that has been used to import prejudice into waiver. And if the court begins analyzing the actual text of the FAA, we may see more and more people from the small business, the mid-sized business community, consumer lawyers like Professor Downs and the clinic there, taking these issues to a jury trial on the making of the agreement to arbitrate. And if that's done in state courts, arbitration is going to look very different than it does now, because sadly, arbitration is being used by some corporations to conceal things like sexual assault. There was a hearing on that in House Judiciary on Tuesday of this week to prohibit the arbitration of sex harassment and sexual assault cases. Certain large chain massage entities use that routinely to force women into arbitration over these issues. And that was never what arbitration was intended for. And frankly, the abuse of arbitration has gotten to the point where a lot of us that are pro-arbitration are sitting there going, folks, this has really gone too far. And the Supreme Court may decide that based on the text of the FAA.
Thank you, Rick, for tying together the look-through jurisdiction back to 1782 and all the way back to the beginning with our preferences. Phil, Angela, do you have some closing comments on this very busy, suddenly, surprisingly very busy November at the Supreme Court in these cases?
I guess like everyone, I'm going to stay tuned and I'll buckle up to see what happens. But we've had a heck of a ride so far, and we're not quite done yet. So always very interested to see what the Supreme Court is going to do and how they're going to interpret arbitration. Certainly hope that they will look to help us somewhat get back to basics.
Phil, is there any last point on any of these three and all of it that you want to sum up?
I think
sticks out.
Yeah, basically on all of it, I'm looking forward to some really some good guidance in 3 areas that are sorely in need of it.
Thank you, Phil. Thank you, Rick. Thank you, Professor Downs. Really appreciate it. You can comment here on our blog and probably on YouTube if it's not disabled. Thanks for joining us, and we'll be back with the results in these cases as it comes up. Thank you all for doing this. I really appreciate it.
Thank you. It's great.
Hey,
Yeah,
bye.
fantastic.
Bye-bye.
Hey, all right, everybody, take care.
All right.